Hi. Today I'm going to talk about SIJS for detainees and updates regarding a deferred action for SIJS applicants that have I-360 approval, where they were able to obtain work permit and be given a deferred action status. Okay, all right. So before we move forward, let's move back and talk about what exactly SIJS is. So SIJS is for children or minors that are, number one, under the age of 21. Number two, they're unmarried. Number three, through a state court petition or in a state juvenile petition, the child was placed under the custody of an individual or an entity. And in that petition, the court has made the findings that reunification with the child's mother or father or both parents is not viable due to neglect, abuse, and or abandonment. And the last requirement is that the court has made the findings that it is not in the child's best interest to return to their home country. Now, in the past few years during the Biden administration, USCIS issued a deferred action provision for individuals or SIJS applicants that had I-360 approval. That's the SIJS petition that was approved. So if you had SIJS and your I-360 was approved and you're waiting to apply for your green card, you were able to apply for your work authorization under the deferred action provision, which was a C-14 category. And you were given a deferred action status, which means that you were given this protection status where you will not be removed or deported. Unfortunately, on or about June of 2025, the Trump administration pushed for revocation of this provision for the SIJS approved applicants. So this revocation prevented clients or SIJS approved clients to no longer be able to apply for their work authorization, and their status as a deferred action was revoked. Now, I'm going to answer the questions that our listeners have asked regarding their deferred action status and what will happen to their work permit and all that. So the first question that we have from one of our listeners is that, what will happen to my work permit? So a lot of our clients have received this notification from USCIS that is it's called the notice of intent to denial or notice of intent to revoke. So that notice is revoking the client's work authorization. However, what I always recommend doing, what I do for our clients, is that we usually respond to that notice by providing documentation to show that our client still qualifies for the deferred action status, because deferred action is a discretionary thing with USCIS, okay? And mind you, there was another thing I forgot to mention, is that there is a lawsuit that's pending, and this lawsuit is, I believe, filed by 19 or 20 different nonprofit organizations that are challenging the revocation of the deferred action. And in this challenge, the lawsuit is filed in a federal court to challenge the revocation of the SIJS's applicants' work authorization, deferred action, and the priority dates. Because right now the priority dates are not even available, or they're called unauthorized. So this lawsuit is actually a very good thing for our clients, okay? But there hasn't been a resolution on it. So stay tuned for that resolution, okay? All right. The next question that we got from one of our other client listeners is that, what will happen to me if I'm in court and I have an approved I-360? Okay, this is a very common question that we're getting. So during the Biden administration, if you had an I-360 approval, a SIJS approval, and you were in immigration court proceedings, the position of the government was usually to move for termination, and a lot of judges were likely to grant the termination, or even if the respondent wanted to move for termination, the judges were willing to terminate immigration proceedings so that the applicant can apply for SIJS, for their green card with USCIS. However, lately there's been a pushback by DHS and immigration because the argument that they're making is that since the priority date is not current or is too far out and they no longer have deferred action, they're moving to continue the case. But from my experience with a lot of hearings that I've done with this type of cases, a lot of judges are still willing to either administratively close the case or even grant termination, even if the government is opposing it. So my recommendation was definitely to move for a termination. But if the applicant has some sort of a criminal history or any other immigration violations, there's a very high chance that that termination is not going to happen. Okay. Another question we have here is that when can I apply, when can I file for my green card? Obviously, you can visit our website for this question to be answered. So once the I-360 is approved and your visa, your priority date matches the visa bulletin, that's when you can apply for your green card with USCIS. And that's if there's no other issues like any other inadmissibilities or criminal records that can prevent you from applying for your green card. So once your priority date is current, then yes, you can apply for your green card. Am I subject to deportation if I have I-360 approval and my priority date is not current? Generally, no. I have not seen anyone that got picked up by ICE if they had an I-360 approved and their priority date were not current. But if they have encountered any sort of criminal records or any other immigration violations, yes, they can be removed. So be very mindful of what you're doing and, what your behavior is outside. This is a very tacky times and we really need to be careful. Okay, the next question and next topic I want to talk about is that we got a question from our listener is that I have a friend of mine who is currently in detention center and does he qualify for SIJS? Very good question. This is a very complex topic. The answer to that question is yes, if they meet the requirement for SIJS. So if there is someone that can petition to be their guardian and they've been neglected, abused, and or abandoned, and it is not in their best interest to return their home country, they can be, but it's very tough. We've actually had a very high success rate with this type of cases. We actually had one that was granted last week, but it puts the court, the state court judge in a very awkward position since the minor under the age of 21 is detained and he's being petitioned by a guardian. So it does put the state court judge in a very awkward position. But if the attorney can advocate correctly and show that they've been living with the guardian or the parent, before, and there's a good positive probate investigation report, there's a very, very high chance that the judge is willing to grant the predicate order for the applicant to apply for SIJS with USCIS. Now, for this particular client that we're talking about, actually no, for a different one, we did get the predicate order signed and the I-360 was approved. And once the I-360 was approved, we were able to file the motion to reopen, and the judge was even willing to grant my client bond and for that client to be released. So if you have someone who is detained and they do qualify for SIJS, they should definitely do it. while their time in detention center has not run out. So this is something that needs to be happen fast. There is a very high chance that you need to file like a motion to stay and to make sure that the client is not removed from the detention center or detention facility, because once they're out of the country, we cannot apply for this relief for them. For more information, please visit our website at www.hamillawgroup.com and listen to our podcast and follow us on social media. Stay tuned.